Yes, Colin.
Could that person say the female, in the case of a female where she felt she was forced to sleep with a boss in order to get that promotion, so she went ahead.
Or to keep her job, right.
Right, she went ahead. And then she decided later on to sue.
Right. Then it's, who do you believe?
Would you still call it sexual?
It's going to depend on credibility. Do you believe her story, that she was compelled to sleep with him to keep her job? If you do, then you'll find in her favor. The fact that she did acquiesce is not going to disqualify her from winning the case. I think that's the point you're after. If you do acquiesce, I mean, think about it if it were the other way. If you get her to acquiesce, then you're insulated from liability. And that would really be a perverse consequence of the law if that were the case. No, the fact that she acquiesced doesn't mean she can't sue, doesn't mean she can't win. All right? Because maybe she really was concerned about her job. These things happen. All right, quid pro quo is really easy. Where it gets messier is with this other theory. And it's kind of what John was referring to. It can happen between colleagues. It can happen with supervisor-subordinate. It can happen with subordinate-supervisor. Any two people in an organization. It's not quid pro quo harassment, but it's called hostile work environment. And sometimes it's called abusive work environment by the Supreme Court. There's no condition of employment at stake necessarily. There's no job threatened. There's no raise threatened. There's no promotion threatened. All right? There's nothing promised necessarily, but the work environment is considered hostile or abusive. And the analytical framework for this comes from a case called Meritor Savings Bank versus Vinson, 1986, if you like cases. That's the seminal case here. But essentially, three parts to this framework. You're going to take the facts that I was giving you before and you run them through this framework. First of all, how pervasive was the conduct? What do you think that means? How consistent was it? Did it happen only once or twice? Did it happen daily? Just how frequently were you harassed? Okay, that's part one that they'll consider. Part two, how severe was the harassment? Right? Did the guy simply ask you out on a date? Did he ask you out on 2 dates? Was the harassment verbal? Was it physical? Did they take pictures of you and put it on the internet? How severe was it? Right? If it was physical, where did he touch you? He touched you on the shoulder? Big deal. Right? If he touched you elsewhere, it might be a bigger deal. So pervasiveness, severity, and the third part is unwelcomeness. Was the conduct, in fact, unwelcome? Or did she invite these advances? And here a court's going to ask questions like, were you receptive to his suggestions? How did you dress? How did you speak? Did you voluntarily discuss sexual topics? Had the two of you had sexual relations before? There are cases where, a woman who's a receptionist in an auto body shop on her break goes in and it's a place full of pornographic magazines and pinups, and she's joking with the guys and telling rude jokes herself and so on. And then she turns around and sues for sexual harassment when a hostile work environment is allegedly created. The court is going to ask, how unwelcome were these advances? And obviously relevant to the court are things like how a person dressed and how she acted and so on. So the things that Adam was saying before, clearly it's part of the analysis. What the court is looking for is some combination of pervasiveness and severity. And the more pervasive it is, the less severe it has to be. All right? If it happened daily, it doesn't have to be all that severe. Or if it was really severe, it didn't have to be all that pervasive. So some combination of this in inverse proportion and unwelcomeness. All right? Now, are we any clearer on this subject? Are we any closer to knowing the answer to, I don't know, if you just run it through, or run some of the questions before through this framework. Boss asks you out on a date. Is it sexual harassment? You would ask, is it pervasive? No. Is it severe? No. Is it unwelcome? Maybe yes. But you have to have all three. Or some combination of the first two and definitely the third one. How about in Melissa's case with the photographs. Is it pervasive? Is there some combination of pervasiveness and severity that you think rises to the level of unlawful action? Well, you would say yes. I mean, maybe, let's say it only happened one time for the sake of argument. Was it really severe? Well, yeah, I mean, posting it for all the world to see, arguably that's pretty severe. Well, let's say it happens 10 times. Okay, so you have some combination of pervasiveness and severity. Is it unwelcome? Well, I wouldn't be going to a lawyer if this were welcome. I didn't invite it. I didn't even know it was happening. Yes, it's unwelcome.
I don't know what the whole thing about posting it on the internet, but did they show the person's face or?
No, but I mean it was obvious who it was, and it was two specific people that were targeted. And the point the attorney made was that it's really, I mean, there were 5 severe incidents, and the attorney said it was a laughy-jokey environment. It was mostly men. The other men in the office, there were 4 men that were willing to testify, but the other men in the office are going to come in and go, it was no big deal. And it gets really gray, and he said that there was a 50% chance, and was I willing to put money on the line? Mm-hmm. And both the female employees, myself and the other person, left.
Okay, but notice what we're getting into here. You're developing the whole environment. You're asking a lot of questions about what went on there and a lot of history to this. I don't know if any of you have ever been involved in a sexual harassment case, but the depositions on these things are this long. I testify in these cases every once in a while because people seem to think that I'm some sort of expert in the area, which sounds a little strange. Hi, I'm an expert in sexual harassment. I can help you get away with it, folks. But they're asking question after question, hours on end, to develop everything about the work environment. Why? Because this is not really an open and shut thing, unwelcomeness. How much did they participate in it? Was it normal for the work environment? She hadn't complained for 3 years. She had been in this work environment. Was it really unwelcome? Or is this complaint really in response to something else? That sort of thing. All right. How about the question of hypersensitivity? Boss asks you out on the date a second time, and the person completely falls apart. Who was it in here that says it depends on the perception of the individual? Jen. Does that matter? I mean, we've got folks who can handle anything and other folks who are going to fall apart if somebody glances at them. At the opposite ends of the spectrum, does how it's perceived by the individual come into play here?
Isn't that part of the unwelcomeness?
Yeah, well, unwelcome to whom is the question. Some people can handle it. Other people can't handle it. Now, the court doesn't go so far as to say it depends on the perception of the individual. The court instead uses what's called a reasonable person test. A reasonable person test. Or in some cases, in some courts, they call it a reasonable woman test. Would the reasonable person, would the reasonable woman find this to be pervasive, severe, unwelcome?
Would that be relevant if the first time she was asked, she said, that really makes me uncomfortable and I'd rather you never ask me again?
So she made it clear that it was unwelcome, right?
So the second time he asked, would that be legally more pervasive than the reasonable
Well, it's
woman
just
test?
as pervasive.
Okay.
And it's just as severe, and it's clearly unwelcome. But would the reasonable person, in fact, be offended by it? That's the kind of analysis that goes on. Yes, Maria?
And who is the reasonable woman?
Well, that's a good question. I've never met one in my life. Ha, 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 ha. Yeah. Well, come on, you open yourself up like that.
I still want to know who exactly is
That
the
is
reasonable
that
woman?
is a great question. In fact,
Exactly.
you could be a lawyer.
Say.
That was the very question that I was asked once. They asked me, have you ever done a study on the reasonable woman? And I avoided snide comments, this being a formal proceeding. But no, I've never done a study on that. Right? I don't know anybody who's ever done a study, and there may be some out there, on how much any woman can take and what the bell curve is and what the average is and that kind of thing. Maybe there's some sort of analysis, but it's really in the mind of the jury is where the reasonable woman is, or where the reasonable person is. All right? The bottom line here is if you want to prove an abusive work environment, you have to demonstrate unwelcome behavior of a sexual nature that's so pervasive and so severe that a reasonable person would find the work environment to be abusive. All right? I'll say it again. You don't have to write it down. I'll give it to you later if you want. But unwelcome behavior of a sexual nature that is so pervasive and severe that a reasonable person would find the work environment to be abusive. All right? Now, is that helpful, John?
This reasonable person test, wouldn't it be difficult, if not impossible, to duplicate the conditions? You know, you can explain the situation, but if you don't have that same person doing the advances, you don't have the same environment, I would find it very difficult.
It's hard to nail this down. You're not going to do some kind of quantitative analysis and come out with a profile. It's very difficult to do. And so it remains this subjective thing in the mind of the jury. All right. Well, are you any closer to understanding sexual harassment law? Maybe a little bit, but is this framework crystal clear? Can you now take a set of facts and run it through and come out with a decision? Well, you may be a little bit closer than you were before. I'll get to you in a second, Colin. But listen to this one quote from Justice Scalia after the one of the most recent U.S. Supreme Court cases on sexual harassment. This is what Scalia says about what the Supreme Court has done with this framework. And he's not dissenting from the justices here. He's actually concurring. Scalia says this: abusive or hostile, which in this context I take to mean the same thing, does not seem to me a very clear standard. And I do not think clarity is at all increased by adding the adverb objectively or appealing to what a reasonable person's notion of what a vague word means. Today's opinion, this is Harris versus Forklift Systems, today's opinion does list a number of factors that contribute to abusiveness, but since it neither says how much of each is necessary, which is an impossible task, nor identifies any single factor as determinative, it therefore adds little certitude. As a practical matter, and this is for you as managers, as a practical matter, today's holding lets virtually unguided juries decide whether sex-related conduct engaged in or permitted by an employer is egregious enough to warrant an award of damages. Now, it sounds like a lot of legalese, but did you pick up on what the Supreme Court is doing here? This was a 9-0 decision, but the justices are essentially saying, we realize we're leaving you virtually unguided. We don't know how to do this any better. It's on a case-by-case basis. You use a totality of circumstances test. Look at all the circumstances. Totality of circumstances test. Look at everything. And then let the jury decide whether, in fact, the reasonable person would find this work environment to be abusive. Right? No single factor is required. Was her job affected? Was her performance affected? Was she psychologically damaged? All these things that come into play, there's no mathematical formula here. So that's really problematic for you as managers. It compels you to make sure you have a clear policy and to make sure that all your employees know about this. Because this isn't just managers. This could be coworker harassing coworker. All right? There could be two folks on the assembly line. You have very little control over what goes on there. All right? But you, the employer, could still be held liable. Or could you? All right? This is the last point of the class tonight. It was John's point before. Where is employer liability here? With quid pro quo harassment, we said the employer is strictly liable. The employer is always liable when quid pro quo harassment happens inside the workplace. But here with hostile work environment, that's not the case. The employer isn't always liable. The employer isn't automatically liable. Does anybody know the standard? Under what circumstances will the employer be liable? Let's say this actually does happen. You prove your case. Melissa proves her case in court. Gets a new lawyer. Wins the case. Yeah, it was hostile work environment. Does she win any money? John?
I was going to mention, as far as the employer, it depends if it's been told to the management and if they've followed up on it and done an investigation and gone through all the proper procedures.
Okay, that's good. That's good. First of all, did the employer know about it? Did they know or should they have known? That's essentially the standard. Knew or should have known. All right, this is the notice requirement, essentially. Did they have notice of this? Did they know about it? If they did not know about it, if there was no way that they knew about it or could know about it, they can't be held liable. There's a case of one lifeguard harassing another lifeguard down in Boca Raton, Florida. Right? Did the woman complain? Did she go to the personnel office? Let's say she didn't. She never told anybody about it. She just turned around and sued the city. Right? Could the employer be held liable about it? Did it know or should it have known about the harassment given the circumstances? That's part of the analysis. Yes, Todd?
No, the recent ruling from the Supreme Court, I think now says, I believe, that it doesn't matter if the employer knew or not.
Oh, it does matter. Oh, it absolutely does matter. Look up Farragher versus Boca Raton. All right, that's a 1998 case. Beth Ann Farragher is the plaintiff there, Faragher. All right, did they know about it, or if they didn't know about it, should they have known about it? This was a small office. I mean, clearly they should have known, given the culture there, given the circumstances of the case. So maybe that's what you're getting at, Todd. They don't necessarily have to know, but perhaps they should have known, given the circumstances. Under this Farragher case, which is the most recent Supreme Court articulation on this. So notice is part of it. The other thing is what they did in response. After they knew about it, what did they do? Your obligation as an employer is to have prompt, remedial, appropriate action. You have to solve the problem. You have to make it go away. All right? As soon as you know about it, respond to it. Do an investigation. A full investigation, a fair investigation, but do an investigation, and if necessary, separate the harasser from the harassee. Doesn't mean you have to fire the person, all right? But that may be the only appropriate action given the circumstances. So notice is part of this. Did the employer know about it? And the other piece of liability is, what was the employer's response? Was there prompt, immediate action? I'm dealing with a case right now where a woman was harassed, and right down the hall was the personnel human resource, the human resource vice president. Told her about it, right? Told the HR vice president about it. Told the company president about it. Nobody did anything about it, right? They knew about the harassment. There was no response whatsoever. That employer is going to be liable, right? Your obligation as an employer is to correct, to remedy the situation. Yes?
Because in our situation, we hadn't been given employee evaluations in a year, and it was an IT department, and that was there was no place else for us to go unless we wanted to take a $15,000 pay cut. And the attorney said that we could probably get away, with the extenuating circumstances angle, but that in going to human resources, that's why we didn't go to human resources. In going to human resources, this employee of the year, employee of the decade, et cetera, this guy won all these awards. You know what I'm saying?
That's a good question. What if the woman never went to human resources? There's a policy in place, she never went there. The question then becomes why? Why didn't she go? Was she really fearing for her job, or was it really not unwelcome conduct? That's the kind of analysis that goes on there. If there's a policy in place, you've got to use it.
But then you tip your hand, et cetera. There could be repercussions.
Yep.
And
that's why there's this totality
really
of circumstances. Look at everything. Mm-hmm. There may be good reasons that they didn't go to human resources. There may be good reasons that they did not exercise their rights under company policy.
But it's still a gamble. I mean, you put out all that money for the attorney, and you just don't know if...
Well, yeah, you could have a private attorney, or you could go to the EEOC. It takes longer, right? If you win under law, it's up to $300,000 under Title VII, but usually there are other things involved, psychological damage, emotional distress, those sorts of things. That's where you get the punitive damages. That's where you get these awards running up to $80 million. Oh, there was one at UPS recently where a guy walked up to her and just squeezed her breast. She sued. The court awarded her $80.7 million.
That is just embarrassing to them.
How about that? I mean, women are like, all right, come on, I can handle it. Just one time, 80.7, that's, you know. Now, routinely, awards like that get reduced on appeals, and this one got reduced down to something like $527,000, but still, that's not bad. You know, I'll take that too. The point is, this $300,000 cap is just if you sue under Title VII. There are other avenues, if you go through a private attorney, emotional distress and psychological damage and so on, where you get punitive damages that can run into the millions, depending on the severity of conduct and the mood of the jury. Yes, Mike. Yeah.
I always think back to the McDonald's case where a lady spilled hot coffee on herself and sued for, what was it, 3 million, 4 million?
Yep.
How, even with all the doctor's bills and the stress, how can you justify giving her $3 million over burning herself? I mean, how
You would
is
have
this,
to ask that
how-
jury. You would have to
That's
ask
just-
that jury. They're very unpredictable. All right? Some of you have sat on juries. You know. My wife sat on a jury recently. You know, they decided that the employer wasn't guilty, and then they turned around and they said, all right, now how much should we give the plaintiff? I know it's late, but pick up on this, folks. They decided the employer wasn't guilty, and then they started discussing, well, how much should they give the plaintiff? To which my wife said, wait a minute, time out. We don't give the plaintiff anything. Listen, folks, and laid it out for them. You know, we're not dealing with rocket scientists all the time on the jury. Juries are very unpredictable. Yes?
Dealing with this mentality, you know, the person by themselves against a huge kind of money-taking corporation.
Yeah.
You know, if
Right,
it's
the jury
McDonald's,
sees itself in-
billions and billions served, well, that must mean billions and billions of dollars. Well, $3 million is pocket change.
Yeah, no, that's a good point. And deep pocket, and I identify with the plaintiff more readily than I identify with McDonald's, and it's that sort of thing. Yes, Sandra.
About minors working in fast food chains or restaurants. Is there any more severity in the charges for sexual harassment for young teenagers?
If, in fact, it's a 16-year-old who's being harassed? Not under Title VII, but if you get into these things about emotional distress, it's easier to prove that a 16-year-old is going to be emotionally distressed by comments than would be a 40-year-old. All right, so there's greater likelihood of hitting the jackpot there. All right, now, any other questions or comments about sexual harassment? There's a lot of information out there, folks, on it. Make sure you stay up on the law here. It's always developing. Oh, you know what we didn't do? Maybe we'll do it next week. You guys are looking tired. We'll do these three scenarios beginning of next week. And this allows us to see how much you retain from one week to the next. So we'll do that. But nice job tonight.
This ends your cassette. There's no new material on side 2.